director, ultimately was the director of the laboratory and the division, with a minor break of 2 years in there where I was chief of staff for public safety.
And as far as training in forensic sciences, you've obviously received much in the educational, in course of your college and postgraduate education. But what other forms of training have you received over time?
So there's specialized courses, professional courses that you can take, which I did in the area of bloodstain analysis, of general crime scene and advanced crime scene methods, of death investigation courses, cold case analysis courses, shooting reconstruction. So I've taken those courses, I've participated in teaching those courses, and currently continue to work in those areas.
And you focus on what classes you teach at the University of New Haven? What primarily are the classes that you teach?
I will teach both the graduate and the undergraduate level. Principally, I've taught a lot over the years, but my core courses are physical methods. Physical methods deals with the disciplines of pattern evidence, such as fingerprints in firearms, and certainly bloodstain analysis is part of that. And I also teach a graduate level course specifically in crime scene reconstruction. And I haven't taught it the last few years, but I've obviously taught crime scene analysis a great deal.
Okay. And you have also taught for other organizations?
Yes, ma'am. Yeah, both as credited coursework and professional development courses.
Okay. Including for the Bureau of Justice Affairs under the U.S. Department of Justice?
Yes, there was a multi-year grant program where I was employed by them to provide courses to prosecutors and defense attorneys. And the two areas I covered were specifically crime scene management and bloodstain analysis.
Publications, have you been published?
Yes, ma'am.
And what types of publications?
I'm a little all over the place somewhat. There's a core group of publications that do involve crime scene analysis, crime scene management, reconstruction. I co-authored a textbook in that area. I've also done more technical papers more in the chemistry instrumental side of it, and most recently I've done some papers in the area of human trafficking and some human rights applications to biometrics and DNA analysis.
Have you been qualified as an expert in any state or federal courts in the course of your career?
Yes, ma'am.
And if you know approximately how many times?
I've testified probably in the neighborhood of 50 times, and where necessitated expert testimony was probably half of that.
And your specialty, your expertise is in forensic science analysis, forensic scene analysis?
I wouldn't term it that way. I think it would be better understood as crime scene analysis and crime scene reconstruction. In addition to that, specifically the sub-disciplines of bloodstain pattern analysis, as well as shooting incident reconstruction.
Now, in that vein, you have had occasion to work previously on the case of State versus Michael Ivor Peterson, correct?
That is correct.
And did you, in fact, testify in that matter?
Several times, yes.
And the first time was at the original trial?
Yes, ma'am.
The second time was at the motion for appropriate relief when the defense was requesting a new trial?
That's correct.
And were there any other occasions where you testified?
No, those are the principal occasions.
In those, at the times you testified, were you qualified as an expert witness
Yes, ma'am.
each time?
Yes.
Then, Your Honor, I would offer Mr. Palmbach as an expert in the field of crime scene analysis and reconstruction.
I wish we heard Your Honor.
Motion is allowed.
Thank you, Your Honor. Now, you have been in contact with me and, prior to me, Mr. Michael Peterson, correct?
That's
Major
correct.
Peterson.
That's correct, yeah.
All right, and what we are here for today is to go through what you have done in the past and what conclusions you have drawn at this point in this case. Now, first of all, as I understand it, when you were first retained, you had an opportunity to view the evidence collected by the Durham Police Department at the Durham Police Department, correct?
Yes, I did.
And how was that procedure conducted, where you were able to look at the evidence?
It was in the Durham Police Headquarters facility, and they designated a separate room, made it available to us. Us being myself and Dr. Henry Lee, we worked together on that. And they brought the evidence to us at our request. We had clean bench tops, we had butcher paper, we had vinyl disposable gloves for everyone. And they would bring us an individual piece of evidence. They would come over, open the piece of evidence. We would then photograph it, examine it, including microscopic examinations, take relevant notes, and then return the evidence and the packaging back to the clerk, who's always with us. And then they replaced it, brought in new gloves, new butcher paper, and a new piece of evidence.
All right, so the purpose of having clean bench tops is what?
The whole purpose of all those activities is to avoid cross-contamination and damage to the evidence.
When you stated that there was a clerk there, was that someone from the clerk of court's office?
At that point, I believe it was agents with SBBI. I believe they were sworn agents, so whether they were assigned to an evidence position or they were detectives, I wasn't sure. They're members of SBI. Yeah.
And were you allowed to handle the evidence yourself?
Yes.
How?
Again, we took the precautions and they made it available to have the clean paper and to have rubber gloves available. We had some disposable pipettes and tweezers that we would use and then discard between the various pieces of evidence. And some of it we would subject to microscopic examination, some of it visible examination, and we would photograph the evidence as well as the packaging.
Now, was all of the evidence that you viewed at the police department, was that all of the evidence seized in the course of the investigation, or if you know, was there additional evidence at the State Bureau of Investigation Crime Lab?
No, we didn't physically view every bit of evidence. We had requested certain pieces of evidence that they made available to us.
And the pieces of evidence you were focusing on at that point in time, and I believe that was 2002 perhaps?
Or thereabouts, yeah.
Okay.
Yeah.
Was what types of evidence were you focusing on at that point in time?
Principally, the clothing of the defendant and the clothing of the victim. I believe we also looked at his son Todd's clothing, and then we looked at a few various items of evidence that were located at the scene. And then subsequently, we had an opportunity to examine the mock stairwell that was part of the SBI bloodstain pattern experiments.
Now, you mentioned that the goal for examining evidence, the evidence in this case, was to avoid cross-contamination, correct? What do you mean when you say cross-contamination?
So proper evidence handling and protocols mean that you're going to do two things. You're not going to damage and remove evidence that's on it. Now, that might be blood, it might be tissue, it might be hair, it might be a fiber. And equally importantly, you're not going to add additional DNA fibers or material from you, principally, as well as you want to make sure that you're examining it in a manner so that you're not making contaminations from one piece of evidence to the next piece of evidence. So how you principally prevent that is first of all, you do all victims' clothing first independently, clean the whole area, move to a new area, get all that evidence out of there, and then begin with a second set of clothing. In this case, it would have been the defendant, Michael Peterson's clothing. And even with that, we would still independently examine one article at a time. And so we're not cross-contaminating even among an individual's clothing from piece to another piece.
is it that easy to transfer DNA from one piece, one item, one piece of clothing to another?
So, in the current status of where DNA is, and it's actually been this way for quite a while, we have the capacity to identify very small amounts of DNA, trace amounts of DNA. You'll frequently hear it referred to as either touch DNA or low copy number DNA. And obviously that's a value to a case because you can, detect very small amounts of a transfer. However, that also means that you have to be extra careful in dealing with the evidence because it would be even easier then to find cross-contamination because the sensitivities of the testing are so low.
When you observed Kathleen Peterson's clothing at the Durham Police Department at the beginning of the investigation, how did it appear to you as far as how it had been secured or packaged by law enforcement?
It appeared properly packaged and secured. I didn't see anything that was problematic or a concern to me at that time.
Now, when you say properly packaged and secured, that requires that certain things occur. We know that Kathleen Peterson was fully clothed when her body was found, correct?
Correct.
And her body was moved in a body bag to the medical examiner's office with the clothing on it.
Correct.
What is the procedure for preserving her clothing or any victim's clothing when the person is moved from one place to another? First of all, why would you use a body bag?
So let's go back to the scene. You have Kathleen present there. You have transfers of materials. There's obviously blood-like material on her clothing as well as high probability of trace. So the goal is to move her in a manner so that none of that evidence is lost and none of it is changed. So, for example, if you had a garment that had some still wet blood on it, you'd also want to make very careful that you're not rolling it all together and balling it up, where effectively you may be masking some pattern evidence. You'd be, kind of restaining an area. So you have to make that consideration as to whether or not you should even, on some occasions, although it's not at all common, we'll make requests of a medical examiner to give us authority to actually remove the clothing prior to the transport. Frequently, that's not necessary, and the stains are more or less dried and set in, and you can effectively occur, or protect against the problem by taking the body carefully and putting it in a clean zipped shrouding. Again, these are disposable and clean, and transporting it to the medical examiner for the postmortem examination.
So the body bag presumably helps protect from any, among other things, any further transfer or any possible mistaken transfer of evidence.
Right, and again, you have an external body bag, but that's not what we're talking about. There's an internal additional sheathing that is disposable, and again, good protocol would say, in addition to using it, you'd maintain it, that you'd keep it on the outside chance that a piece of trace fell during the transport.
The clothing that you observed, when you observed it, did it appear that it had been folded up, rolled up, such that there could be transfers of stains from, say, the right sleeve to the left sleeve or onto the chest?
It's always a subject of our examination. In this case, I did not see any indication that had occurred with her clothing, or Michael Peterson's clothing for that matter.
The proper way to handle, say, a sweatshirt in this case, and that had much blood on it. When Kathleen Peterson's body was taken to the ME's office, they would remove it?
Yeah, it's generally speaking, it's at the point that examination occurs, you'll have a detective or a member of SBBI, some of the investigative evidence collection group will actually be present with them, and they'll generally work in conjunction with the medical examiner and her staff so that, you can get additional photographs, and they'll help coordinate the collection of the evidence as it's removed by the medical examiner and their staff, and then properly package it.
And proper procedure for, I'm going to use the sweatshirt right for now.
Sure.
Upon removal, the collecting detective would do what with that?
Ideally, they'd put it on a flat piece of clean butcher paper, put an additional piece of clean butcher paper over the top of it, and so then whether you choose to fold it or roll it, you have protective surfaces just to be sure that you won't get that cross-pattern transfer. And then,
Top and bottom.
top and bottom, yeah. And then if there's any indication that that's still damp, then it's common practice, you're going to have to transfer it away from the medical examiner's office, but before you put it into long-term storage, you're going to want to put it into a drying rack or a drying bin, or ensure that it's fully, completely air-dried.
Why?
Well, there's lots of reasons, but the principal reason is that humidity or dampness in the garments or failure to dry the blood will create an environment, particularly if it's an airtight environment, where you'll get rapid bacterial growth, and that will degrade the DNA often to the point that it's not capable of being examined.
And when it is dry, what is the best way to store an item such as a bloody sweatshirt?
So once it's dried and it's properly packaged in a breathable container like a paper bag, it just has to maintain in a low humidity room temperature environment.
Will a paper bag keep it from being contaminated with additional DNA? Is that sufficient?
If it's sealed.
And when you say sealed, is tape acceptable, staples, or is there some special sealant that's required?
Yeah, well, the best practice protocol is to use an evidence tape, and so that gets a complete uniform seal. And evidence tape is also tamper indicative. It's meant that you can't peel it back and reseal it. If you try to do it, it'll break. So it's an added mechanism to maintain the chain of custody and establish that that seal's intact.
And so when you observed the clothing first at the Durham Police Department, was it in paper bags?
Yes,
Were they sealed?
yes.
What was the condition of the paper bags?
It was dry. It appeared fine. No issues.
Were they torn or battered in any manner?
Not at that time.
So they were in good condition, new condition?
Good condition, yeah. The way I'd expect them to be.
Okay, all right. And now, do you know if you observed them before or after DNA had been collected from the items of clothing?
I was not aware at that point when we examined them if there had been DNA and if it specifically what they would have done or where they would have tested it.
Would you have expected the DNA, is it standard operating procedure to collect the DNA prior to storing the item in evidence?
Yes, early on in the investigation, that would have been a standard practice to have that analysis done.
Who collects DNA? Would it be the detectives or a crime scene specialist, or would it be the DNA lab?
No, that's a function that's, when you're talking about clothing, certainly a crime scene technician can collect blood stains and other DNA-bound stains from a crime scene, but once you secure the clothing, that protocol would then be to bring it to the lab, this case, the SBI lab. And I'm not sure the structure of their agency. And they're both fine. There are some labs where you have a separate forensic biologist, is what we would call them, where they're going to do the preliminary screening and examination of the clothing, and then they'll take the sampling, which is usually just a swab, of the areas that they want to have DNA tested. Other laboratories will have their DNA analysts go from the early screening and swabbing right through analysis. So both's fine. I think it's just a different option.
Are you aware of how it was done in this case?
I'm not.
Okay. Nonetheless, there were no issues that you observed or concerns that were raised when you observed that evidence prior to trial.
That's correct.
were you present during the trial or were you sequestered?
I was sequestered only for my own testimony.
During
There was a day, I think in an early hearing, where I actually was present, but predominantly I was not. It was just my testimony.
Did you have occasion yourself to use or touch any of the clothing in the course of your testimony in the trial?
I did not.
And by being sequestered, you didn't see how the evidence was handled in trial by other witnesses?
Right. My only qualification is subsequent to that. I've seen, I think, most of the film and TV footage, and I think some of that was dealing with in the courtroom.
In a trial, what is the best practice for handling evidence when it's being introduced or used for demonstrative purposes?
The same as anybody else. The bottom line is evidence collection, preservation, and handling is a baseline procedure that's incumbent to be maintained from the day the first government official finds it and picks it up, all the way through the trial process. And whether a defense expert or a state lab expert or anybody else is handling that at any point in time, they have the same obligation to protect the evidence, and therefore they have to maintain the same standards of care with rubber gloves and caution not to cross-contaminate and the proper handling.
Okay. Let's say you and I are in a trial, and I approach you, and I give you a paper bag that has tape on it, evidence tape and initials and so forth. I present it to you and ask you first to identify, correct?
Correct.
And then I ask you to open it to display to the jury and for demonstrative purposes what is contained inside that bag. What is the best practice for opening the bag?
First of all, I would request a butcher paper, some kind of covering, and I would request vinyl or rubber gloves. And I would request a scissors or some sharp instrument so that I could properly open the bag, which means we're going to cut it open in a area that's not previously been opened and sealed, or cut it through somebody else's initials and then gently remove the article.
Should you pick the article up and display it to the jury, to the court, to the opposing side? Is there any protocol other than using the gloves as to how you handle the piece of clothing?
Again, I wouldn't let anybody just randomly come in contact with it. I wouldn't brush it against other surfaces. I wouldn't cough or sneeze on it. But beyond that, no. That's fairly common practice.
When you complete your testimony or use of the evidence, do you just fold it back up then?
No, if I'm in the courtroom or any occasion where I've done this, no, there's really not the time. I've never had the time to do it nor the inclination to do it. If it would happen here, I would push the piece of evidence to the side, and once I'm sure I'm done with it, I'd place my rubber gloves off and complete my testimony. And when the judge dismissed my testimony, I would go. So, in my understanding, that evidence belongs to the court, and it would be up to them to deal with that and properly repackage it.
Now, you have been in court, I assume, where you were testifying and counsel for the state or for the defense picked up articles and handled them as well?
I have seen it occasionally.
In the course of asking questions and presenting their case?
Correct.
And what is the proper protocol for their handling of the evidence?
In my opinion, they should have rubber gloves as well.
Why?
Again, you're avoiding cross-contamination.
Is that something that you have typically seen in cases where you've testified?
I've seen it both ways. Sometimes with, sometimes without.
Okay. Let's suppose that a witness or a party to the case picks up that sweatshirt, I'll continue using that, and walks around carrying it without gloves. Would that destroy the ability to do any form of DNA or touch analysis of the piece of evidence?
It complicates it. It wouldn't prohibit it. Again, it's not good practice, but in that scenario that you described to me, we'd have two elements. One, you'd know who the person was that touched it. So you could ask for, or if necessary, I guess court order, a known buccal sample, and so we'd have a known DNA standard for that individual. Secondly, we would know precisely where they touched it. So if subsequently that piece of evidence, for whatever reason, the trial needed to go back now for a DNA screening, we'd at least know, well, if it was videotaped, we'd know precisely. I guess if not, we'd only know generally where the person held it and try to avoid those areas.
But if you had, in this situation, with the sweatshirt, DNA from Michael Peterson and DNA from Kathleen Peterson, that would be expected because they're husband and wife, correct? And
No, not necessarily. I mean, it's whether or not there's going to be cross DNA between a spouse. We'll start with, is it a freshly laundered object? Did I get up this morning and take a clean starched white shirt, fly down here, to North Carolina, and not, now I come home and I throw out my laundering bag, there'd be no expectation that you'd find my wife's DNA in that particular case. So I don't think you can jump to a conclusion that just because you're cohabitating that you would have a crossover of DNA.
if you had information that Michael Peterson held Kathleen after she died and was crying over her, would you expect to see some of his DNA on her clothing?
Yes, and again, but not uniformly, but in relevant areas. So, I was aware of the assertion that Michael held her, and the way that it was explained or known to me was that he was on the staircase and her head was more or less on his lap. And I would say our examination of his clothing supported that. The blood stains that we saw on his clothing were consistent with that type. So yes, in that situation, you based on that interaction, you would expect in that location of the clothing to find a mixture of both Michael and Kathleen.
If you wanted to check that sweatshirt to see if there was a third person's DNA on it, for instance, whether or not a third person may have been the guilty party, may have killed Kathleen Peterson if she was murdered. What would you look for if you know that other people have already touched it without using gloves? Do I need to break that down?
Well, if we're talking specifically about Kathleen Peterson's sweatshirt in this case, it's the way in which it's handled, the current state of it. In my opinion, it's absolutely, you can't do anything with it. There's no capacity to do subsequent DNA testing where you could have any reliability on anything that was developed.
Why?
Because it's been open and accessible. In this case, you have two issues. You have a critical issue that you have amongst this box of open evidence. You have Michael Peterson's sneakers, which definitely is going to have his DNA on it, and you have Kathleen's clothing, which definitely going to have her DNA on it, and they're effectively open and exposed in a line adjacent to each other. From that moment on, it would be irresponsible to make any assertion about whether a transfer did or didn't occur, and if so, how it got there. So you really preclude that whole line of testing. The other problem is in that case, there was other garments of clothing that were in that box, plus they're open and available, which meant that, and I know that there was a movement of the evidence from one courtroom to the next. there's numerous opportunities, therefore, those garments could have been subjected to or exposed to an unknown third level of DNA. And you're going to get to the point where you're going to have these unknown profiles of DNA being generated on the clothing, and they have no relevance to know to whom do they belong. Is it truly an innocent explanation, or is it potentially a really legitimate third party, somebody who had involvement in this case that would be highly probative? And it's further complicated. Once we have a mixture environment, you cannot then swab that piece of clothing and take that sample and put it into the CODIS or the unknown DNA database. In order for us to do that, we would need a single source sample. So now that you have a contaminated, cross-contaminated mixture-based sample, we preclude the ability to do a CODIS search. And the value of that would be if we were to swab, or let's say we swab Kathleen's sweatshirt or we swab her sweatpants, and it's a single source, and we upload it into CODIS because it's an unknown entity. CODIS, again, is this national DNA database. If it hit against an individual, then obviously the police have got some work to do. I mean, then there's somebody that they need to find out who is that person, how did they have access, is it related to this incident or not?
Okay, let me back up. Let's suppose that the evidence is that during the first trial that defense counsel handled some of Kathleen Peterson's clothing without gloves, that the district attorney trying the case handled the clothing without gloves, and perhaps the detective on the case or detectives handled the clothing in court without gloves. Let's say one detective represented the state representative for Michael Peterson. Those are three known individuals. Wouldn't that be acceptable to go and pull the DNA and analyze it from her clothing?
Well, again, I think I'm going to clearly state that's not ideal. So I would hope that wouldn't happen. But if it did, the difference in that scenario versus just an open exposure to an unknown third entity is we would know who these people were. We could get a known DNA standard from them, and then through the analysis of a stain, we could make an attribution or either include them as a source, a potential source for that stain, or exclude them. It would be also very advantageous if we had those actions photographed or videotaped, because then we could like narrow it down. Let's say you picked up the sweatshirt and held it up, and we had it videotaped or photographed. Well, we're not necessarily from just that issue going to have to discard the entire sweatshirt. We could just discard that element, the areas where that contact is. We could physically identify that. That would be very beneficial.
What if you were talking about a mixture environment? You mean, when you speak of that, a mixture of DNA from different people?
Right, yeah. When you have a mixture in the DNA world, we're saying that the profile that we generate, the pattern we generate, has to be attributed to more than one individual as a donor. And again, what happens is, as those mixtures increase and they get more and more, it's going to preclude our ability to give truly meaningful results. And often you'll get to the point where your mixtures will be so comprehensive that you really can't easily include or exclude any individual. And you certainly are prohibited from the true value of CODIS, of a random database identification.
Because it wouldn't be, say, what we call a pure sample?
Yeah, that system.
It would be only my DNA, correct? And that would be...
Right. For that system to effectively work the way it's structured, it's looking for a non-mixture sample.
All right. In the course of a trial, well, may I approach, Your Honor?
Yes.
I'm going to show you some photographs that were taken of evidence in December 2015 for your review. They're
If
already
I may
evidence.
approach so I can see.
I'm so sorry.
Yeah, I'll put it right there. You can put it there, I don't care.
I'd like to show you photos that were previously admitted in evidence in a prior hearing. First of all, exhibits 13 through 16, asked you to look at those, and I believe you've seen one of those previously, is that correct?
They all look familiar to me. Yes, I've seen them.
Okay. And those are, as you can see on the markings, evidence from a trial.
Correct.
And they are the evidence that was introduced in evidence during the trial of Michael Peterson. Do you see any issues with how those items are packaged in the box that contains them?
Absolutely.
What issues do you see with those items in the box? Let me back up. Would you describe what you see in the box first, and then we'll discuss what you see as issues?
Well, the box contains several paper bags. It also looks like it contains some kind of reports or documents on the bottom portion of the box. The key points of the evidence that I see that I want to reference to is the top rear portion of the box, as you'll see in this photograph, is a wide open bag containing, and these are fully consistent with the gray sweatpants from Kathleen Peterson. And again, it's completely open across the entire front of it. So you have blood and urine and major areas of this particular pair of sweatpants that are exposed. In addition to that, directly below that is another bag which is effectively torn in half, such that there's a pair of white sneakers that the entire back half of the sneakers is now completely exposed. And these are fully consistent with the sneakers that I examined and were identified as being Michael Peterson sneakers.
So you have evidence from the victim and from the defendant in the same container.
Yeah, and I would add to that, it's not just evidence, it's critical evidence. These are bits of clothing where we did observe biological materials and transfers in blood and other body fluid transfers and pattern evidence, and so they're very relevant to our analysis in this case.
Why?
Because the evidence is clearly on them, and the fact that one was worn by the victim, some of it was worn by the defendant, and at least some of the theories that were offered in this case were suggested that a struggle had occurred, or that the victim was succumbed to a beating type death.
And how does that theory impact what you're seeing in the box?
Well, in that basis of a theory, one's going to expect contact between the assailant and Kathleen Peterson, and in a contact between the assailant and Kathleen Peterson, one should expect a transfer of small amounts or trace amounts of DNA. And so all efforts have to be in place to protect against the cross-contamination, so that at some point, if necessary, the testing could be done to identify that trace DNA.
Now, this is post-trial, however. This is, or during the course of the trial. And so if DNA analysis had been done on Michael Peterson's sneakers and on Kathleen Peterson's sweatpants, would that be an issue as to how the evidence is being handled?
Well, assuming that they did it appropriately, which would mean that they swabbed sufficiently, they collected sufficient numbers of samples from the appropriate regions of these articles of clothing, and you had those results, then no, then you would have had the results, and you could work with those results.
In fact, the clothing of Kathleen Peterson was not tested for DNA.
That is my understanding.
And so the question now is, this many years later, or these many years later, can evidence that was stored, such as those sweatpants, can they be analyzed for DNA?
Based on the condition here, absolutely not.
Well, could DNA be collected from the pants?
Pragmatically, could you swab it and go do a DNA test? Certainly. Would the results be reliable in any fashion? No,
Why?
because of the cross-contamination. So if you found, and let's specifically say, you found a transfer in a particular area between Michael, a trace transfer, low copy number, and Kathleen, given this cross-contamination, you can't make it an inference that that contamination was a result of the crime or the incident. You'd have to understand that it's just as probable that it's a result of cross-contamination and doesn't have anything to do with the case.
The proper way to have maintained the evidence from the cow would have been what?
Well, simply, if these bags have been fully sealed, and you should never, in the same container, store the victim's clothing and defendant's clothing. That shouldn't happen either. So assuming that they had properly segregated the clothing and that it had been properly sealed, and they had maintained it, again, in a reasonably low humidity environment and room temperature, I think you'd be fine. I would expect you'd be able to get DNA profiles.
When the bags are just torn open, and I think it appears that at least one of the bags in those photos is quite damaged, what is the best practice for maintaining evidence that is no longer completely covered in the bag it was originally stored in?
Right, so you're not going to get rid of that bag because it's got all kinds of very relevant notations and signatures that are pertinent to establishing and maintaining a chain of custody. So you would take the article of clothing plus the fragments, all the fragments of what's left of the bags, put them in a new clean bag, reseal that bag, relabel that bag.
Okay. But keep the first bag as well
Sure.
inside there with the evidence.
Correct.
All right. And how could to what extent, I guess you probably answered this, but I'm going to ask again. Let's say the sweatshirt or the sweatpants, based on video, shows that 3 people in the course of the trial touched the evidence. And they are known individuals, and the video reflects where they touched the evidence. Would it be reliable in any manner if yet another person's DNA was found on the clothing at this point in time? In other words, you've excluded the court witnesses or personnel that have touched it. You know what their DNA is. You know you have a known sample of Michael Peterson's DNA and Kathleen Peterson's DNA. And then there's 1 or 2 other samples of DNA that show up now on the clothing, would that be reliable evidence?
Well, if it wasn't found in this state, so if the stipulation is that those touchings occurred in the courtroom, but then it had been properly preserved, then yes, I think you could still potentially get reliable results.
But barring the proper packaging and handling, it can't be a reliable result if
That,
the
yeah,
DNA.
the current status of it right now, to me, renders it completely unavailable for testing
Okay.
of
And-
DNA.
Okay, and DNA could have gotten on any of that as easily as someone sneezing over it,
Sure.
who has nothing to do with the case at all?
Yep, or perhaps in the fact that they're finding various other objects in the box means, you know, that somebody was handling that and moving objects around, and if it was, they handled it, moved it around in this current state, I'd expect a transfer to occur from them as well.
If that evidence was in one type of box initially, after the trial, and I'm sure you recognize this is a different courthouse than the one you testified in previously. In the course of moving evidence from the old courthouse over to this courthouse, it was repackaged in new bags, or new boxes, excuse me. Would that further undermine any credibility as to DNA results?
If it was fully sealed and properly segregated, victims, defendants, then a person, again, taking normal precautions, wearing gloves and proper handling, moving it from one box to another, I don't see it as being ultimately detrimental.
And if in the course of perhaps moving it, evidence from other cases is added into the box, such as photographs of a crime scene or police reports, would that further undermine the possibility of getting any reliable DNA results,
Certainly. Certainly.
even if it's paper?
Sure, people touch paper. And again, you could get a transfer from a photograph or an object directly onto one of these surfaces that are now exposed.
And so your conclusion, if asked, can Kathleen Peterson's clothing be analyzed today, moving forward from today, to determine whether or not, or to determine whose DNA is on her clothing? Can that be done? And can a reliable result be obtained?
Yes, you could do it. No, you would not have a reliable result.
Okay. Excuse me 1 second, please. Just one more issue. You were talking about maintaining evidence at room temperature. Accepting that this is North Carolina and our summers are fairly warm, if it was in an unair-conditioned room, if it was maintained there for a number of years, would that cause a problem with the quality of the DNA that might be obtained now?
It could. I'd have to know how hot. I mean, extreme heat could denature blood and other biologicals and create a problem. I would be more concerned with humidity control. So my bigger concern would be, it's truly that hot, is there any capacity to dehumidify the area? And so I would be more concerned of the negative effects of high humidity.
If there was a pipe that broke in the storage area, there's no evidence that the boxes or the evidence in this case got wet, but a pipe broke and there was water pooling in the area, would that be detrimental to any DNA analysis?
Oh, I assume if it's left for any period of time. I mean, I wouldn't know how big of a room and how far, and did they clean it up in 2 minutes or 3 days? That's all going to matter. But yeah, again, anything that's going to increase humidity, certainly water on the floor would do that, is going to be detrimental.
And would cold be an issue?
No, not dry cold.
Your Honor, I tender the witness.
All right.
Yeah. Now, sir, you've indicated that you've had training, classroom training as well as, I take it, field training as well?
What, I'm sorry, what kind of training?
I'm sorry, as far as within your expertise of crime scene reconstruction and blood stain pattern analysis, you've had not only courses within the classroom, but also on-scene training, is that correct?
Correct.
And from who did you train under?
I've trained under, mentored immensely, so mostly Dr. Henry Lee, but also Dr. Herb McDonald, Paul Kish, and then I've worked with, in coursework, and then I've worked with countless other experts in conjunction. So as you work with other experts, it's an effective training mechanism as well.
And how long did you work with Dr. Henry Lee?
Directly since approximately 95, 96, somewhere in that time frame.
And are you still working with him?
Yes, sir.
So 20 years, give or take.
Give or take.
Do you have an opinion regarding his expertise as far as in the field of blood pattern interpretation and analysis?
Objection, Your Honor, relevance.
Overruled.
Well regarded.
In fact, would you say he's at or near the top of the field?
I don't know that I'd highlight any individual as the top, but he's absolutely well regarded as one of the leaders and well-respected members of the community.
You testified previously, you indicated, at the trial as well as the motion of appropriate relief.
Yes, I did.
And do you recall testifying under oath? And this is, and I'll get to the, at a later time, Your Honor, the transcript, but just for the record, this is going to be page 11390, lines 14 through 17. You recall stating, I have the opportunity to work with Dr. Lee, who at least in my opinion is the absolute top of the field, as well as a variety of other very, very key experts.
Yes, I believe so. I said that.
And you actually worked with Dr. Lee as far as examining the evidence in this case in order to form an opinion regarding the blood pattern analysis in this case. Is that right?
Correct.
And in reading some of these, you said you referenced good science is good science. Do you recall saying that?
No, but I agree with it.
And if you do things right, if you take an objective viewpoint of the evidence, you can then form conclusions which can hold up to scrutiny and are supported by the evidence. Is that what you're referring by good science is good science?
Sounds correct, yes.
And in reference to this particular case, you generated a report regarding your your opinion regarding blood, stain pattern analysis and reconstruction. Do you recall that?
Yeah, the original report was co-authored between myself and Dr. Lee.
And because the two of you were working so closely on this together, is that right?
Correct.
And in fact, you signed it, but Dr. Lee wasn't able to only because he was out of the country in China, but he did adopt it. Is that your understanding?
I don't know that to be true, but I simply don't recall.
Okay. If you had testified to that and defense counsel represented that to the court, would you have any issues with that?
No.
Do you recall signing the report?
Yes,
Would you recognize that report if you were to see it again?
I would.
Let me put you on.
Yes.
So here was Marcus exhibit number 1. You recognize that report? Yes.
Yes, I do recognize it.
And is that the report that you prepared in anticipation and of testifying as far as putting forth your opinions and that shared by Dr. Lee?
Yes, we obviously co-authored this report.
And did you form your opinions independent of Dr. Lee, even though you may have been looking at the same evidence? Did you make up your own mind so that you could form your own opinion and he as well?
Well, this does represent our submitted report in total for the case.
Okay.
We had different roles during the testimony, as obviously was seen.
Okay, but that was a testimony, but as far as the analysis and examination of evidence, you worked together with Dr. Lee, correct?
Yes, we did.
And you formed the same opinions regarding what you observed regarding the bloodstain pattern, is that correct?
I stand by the report, if that's the question you're asking.
And yes, do you have the same opinions as Dr. Lee?
I stand by the report.
Okay. Well, I understand the report, I'm asking if you have the same opinions as Dr. Lee.
Well, he was on the stand and he gave testimony independently, so I can't tell you that I know exactly every word that he said on the stand. And therefore, at this point, what I can assure you is I stand by this.
Okay. And in order to form the opinions within that report, you had to examine different photographs, is that correct?
We did.
And you also examined physical pieces of evidence, is that correct?
That is correct.
And you actually went, and this was brought out, I believe, on direct, you went to the Durham Police Department and observed the actual clothing worn by the decedent Kathleen Peterson, as well as by Michael Peterson, and I think you also mentioned some items that belonged to Todd Peterson, is that correct?
Correct.
And the purpose of looking at those in person and seeing the actual items as opposed to just the photographs is so that you could, in case anything was missed in the photographs or something that you want to look at in closer detail through microscopes or through different lighting, is that correct?
That's correct.
And in fact, that actually occurred with Mr. Peterson's clothing, that you looked at it under greater magnification and under different light sources. Do you recall that?
We did that with all the clothing.
Okay. So you did that with Kathleen Peterson's clothing as well?
Correct.
And you mentioned that one means of obtaining a DNA or potential DNA sample from an item of evidence is to take a swabbing, is that correct?
Correct.
Another means would be to potentially take a cutting and consume the cutting to determine whether or not there's a DNA profile within that cutting of, say, fabric or clothing.
Not ideal, but you could do that, yes.
And obviously, if there was a cutting of the fabric or clothing of either Mr. Peterson or Kathleen Peterson's clothing, that would then in some way alter your ability or in some way infringe your ability to observe the item in its totality when examining it for blood pattern analysis. Isn't that correct?
That area that's missing is missing, therefore we couldn't interpret it, right? Unless maybe there's photographs, so it may not be completely lost.
Okay, but you decided, as well as Dr. Lee, that in addition to looking at the photographs, you wanted to see these items firsthand. So in case the photographs weren't documented or weren't showing something that may have been missed as far as with the naked eye or under different lighting. Is that correct?
Correct.
And in fact, when you examine these items at the police department, you indicated that the packaging was as you would expect it to be, correct?
Correct.
That these items had not been, based on your observations, altered by means of cutting or other manipulations that had removed a potential pattern from either one of these clothing items. Is that correct?
Correct.
And that certainly then assisted your ability to form an opinion, which you ultimately provided within the report and Dr. Lee ultimately as far as his testimony.
Correct.
Now, you've held a number of positions throughout your career, and I get the impression that you're not just an administrator. You can do these tests as far as not just the blood same pattern, but if we're talking about DNA, you can do that yourself. You know what it encompasses, or am I wrong on that?
Yeah, I would not consider myself competent to run a DNA analysis. I understand it very well. I understand the data,
Okay.
which is so critical to my reconstruction capacity, is to understand the data, what it means, what it doesn't mean, and how to properly apply it. But no, I'm not certified to go, and my staff would kill me if I went and jumped on their instrument.
Okay, but you mentioned your staff. So back when you and Dr. Lee were coming, I take it down here to Durham to examine the evidence, at that time within the, and forgive me if I get it wrong, I'm gonna refer to it as a forensic institute,
Yeah.
that you were associated with. There was the capacity within that institute to perform DNA testing. Is that correct?
Well, I actually was, at that point, the director of the Connecticut State Police Crime Laboratory. Yes, we did DNA testing, but no, I would not have the authority or the opportunity to do DNA testing on a case from North Carolina.
Okay. Well, you couldn't just come and take it at your own will. Is that what you're referring to?
I couldn't come
If
and
there had
take
been a
what?
court order to allow you to do that, you could have, the testing could have been performed, correct?
If there was a court order or permission to swab, which there wasn't,
Okay,
but if there was, yes, I could obtain the samples, but it would have gone to a accredited private laboratory, not to a state of Connecticut
Okay.
laboratory.
But-
Yeah.
So there was so the opportunity was there if a court order had been obtained in order to obtain it, to conduct DNA testing.
Yes,
And you weren't aware of any court procedures or court proceedings rather in which the state fought or tried to prohibit any type of DNA testing by the defense? Are you?
I wouldn't be aware of that.
Neither you nor Dr. Lee requested any type of DNA testing, is that correct?
That's correct.
Now, I don't want to get into what may have been told to you by the defendant, but there was nothing prohibiting you from asking that that be done, DNA testing, is that correct?
That's correct. If we felt it was warranted, we could have asked.
So although the opportunity was there to ask, the question never was asked. There was no request, to your knowledge, or at least based upon your actions or Dr. Lee to have these items tested. Is that correct?
Well, I can only account for the two of us. Neither of the two of us made that request, right?
And according to your previous testimony, the items that were in the possession of the Durham Police Department at the time that you saw them, prior to trial, were packaged in such a manner that you did not have concerns regarding the integrity of those items at that time. Is that correct?
That is correct.
Now, you mentioned that subsequent to your testimony at trial, that you had an opportunity to view some portions of the trial as it was being re-aired on television. Is that correct?
Portions of it, yes.
And did you observe the manner in which items of evidence were being handled in court by different personnel, either a evidence technician that had taken the witness stand, or a detective, or an attorney, either the defense or the prosecution?
I'm sure that was part of the tape, but I don't have a specific recollection about it.
Okay. And, well, let me ask some questions then about DNA and I guess cross-contamination, so I have a better understanding. If I touch something, then I may leave my DNA on that item. Is that possibility, correct?
Yes,
Although it doesn't necessarily mean that my DNA actually was left. There could be different factors that would affect that, such as, I guess, a surface, whether or not my hands are sweaty or not, or if I have a fresh wound, whether or not there's blood, or something of that nature, or some sort of bodily fluid. All those things could affect the ability to transfer DNA. Is that correct?
sure, but when you're talking touch DNA, it doesn't necessitate blood or open wound. You're effectively talking touch, skin cells, basically.
Okay. And so if I was to touch this pad, then there's a possibility that now my skin cells have been left on this pad.
Yes,
And then when I put my pad down on the table, there's a possibility that those skin cells went from the pad onto the table.
so now you're into a secondary transfer, and there's been lots and lots of research on that, and lots of debate. And that does not occur anywhere near as easily as the direct transfer does, but it can occur.
And in fact, you talked about what you consider to be the proper methods of viewing evidence in a courtroom, and you talked about putting it on a piece of paper.
Mhm.
And you're not talking like a newspaper, is this, what type of paper are we talking about?
It's clean butcher paper, white paper, sheet
what's-
paper.
I'm sorry, I'm sorry
No.
to interrupt you. What's the purpose of doing that?
Well, to protect against putting some of whatever that material is on, let's say this bench, and also to protect the item from any DNA or other trace materials on the bench. It's a both and.
Okay. And in fact, when being questioned by defense counsel, you referenced, and I don't think you did it all in one sentence, but you talked about if somebody was sneezing over something, then obviously there would be a DNA transfer, correct, if you sneeze on something?
Likely, yeah.
And even though you talked about the fact that the likelihood is rather low, you even mentioned, yes, paper can transfer DNA.
It can.
And if an individual were to say sneeze or cough on a surface, then if you were to put an item on that surface, there's a potential then for that DNA resulting from the sneeze or the cough to transfer to the item that's put down on that surface.
Absorption, drying time, surface tensions, all is relevant, theoretically possible.
And as far as items of evidence, you mentioned that, in your opinion, the proper means would be also for the person who's handling that item to be wearing gloves,
Yes,
because then that person's, if not, that person's DNA could get on the item, correct?
correct.
And theoretically, if that person just touched something, then they may have DNA from another item on their hands, and that could transfer as well, just like if an item was left on a surface.
Well, again, once you leave the direct transfer and you get into the secondary or tertiary transfers, the probability of those transfers is greatly diminished from a principal transfer.
You certainly don't want to take different items of evidence and put them together. You don't want to take different items of evidence that have been separately packaged and then in a courtroom kind of commingle them and put them together, do you?
No, you should try to avoid that.
In fact, that would be a means of potential of commingling with the potential for contamination, correct?
If the extent was substantial, yes.
And I get the impression that as far as when we're talking about transfer and contamination of DNA evidence, that once that bell is rung, you can't unring it, so to speak. Once it happens, you can't then separate them, can you?
Right. Once you've got a contaminated piece of evidence, then that locks down prevents your capacity to have a meaningful analysis, interpretation of the data.
And if you don't know what DNA is on an item to begin with, and then there's conduct that could result in contamination as a result of commingling, and there's multiple occasions of that occurring, you can't say when the contamination occurred as far as whether it was the first time there was commingling, or the second time, or the third time if that's occurring.
That's the inherent problem with contamination, is that you now have an identification of some biology on an object or some material on an object with DNA, and you don't have a good indication of the when and how that occurred. That's correct.
And in fact, when defense counsel was asking about, well, as far as if you saw somebody on tape handling something, you can get that person's DNA profile. So you can say, well, if their DNA is on there and they don't, we're able to eliminate the ability to get that DNA on there other than what we see on tape, then we can get that person's DNA profile and figure out, okay, we know how it got on there.
Mm-hmm. And thus eliminate them, yeah. Or identify them as a source and then eliminate have an understanding of how it got there.
How,
Yeah.
because DNA evidence in and of itself doesn't really, does it tell you how it got on there? If you're just looking at it in a vacuum and saying, okay, I've got this DNA on here, that won't tell you how it got there, will it?
It can lead to that.
Okay,
So if your rational reason for collecting something is you make an observation, so there's a blood stain, we see something red, we swab that blood stain, we get a single source DNA profile, then you can attribute that to the blood. That's what's created that. So now at least you have some information as to what created it. You'll have to go back and look at when did a blood shedding event occur or not occur. Maybe in another situation, you had somebody grabbed the shoulder and pulled on an individual and tore the garment. And so you'll see a tear in the garment, which would be a classical indication of a sign of a struggle. Sample that area, do a DNA analysis of that area. Let's say that came back to a single source profile. That would be relevant because in conjunction with our observations of the tear, indications of a struggle, now we could attribute the probability that that DNA sample is a result of that struggle.
and when we're talking about, you mentioned, I think the first incident you just mentioned would be a red spot, and then it's tested and it's blood, and then you can then try and get, and most likely will get a DNA profile since you have visible blood. If there is a commingling of blood, of a DNA source from blood and a DNA source from skin cells, from touch DNA, can you make a determination which one it comes from?
So you're hitting another issue here, and it's the potential imbalance between what we call the major component and the minor component. So let's say we had a drop of blood, and then a finger touched a drop of blood, so we get a transfer of a few skin cells. So you swab that whole stain. So proportionately, the volume of DNA that's available from the blood will be the major component. The one or two skin cells will be the minor component. And what actually happens in the whole DNA process is step one, we extract it, and then we quickly go into a replication process where through a PCR replication process, we're going to make multiple copies of that DNA so that we can analyze it. So when you start copying DNA and you start with an imbalance, 1,000 units of one and 1 unit of another, exponentially you get to the point that there's so much more of the major component that you don't actually end up seeing the minor component.
So the minor component, does it get masked by the predominant
yeah.
DNA profile?
If the imbalance is significant enough, yes.
And now, you testified that in regards to, well, first you testified, and I believe not only here, but also at the trial, and there was other testimony that at some point, Mr. Michael Peterson had contact with Kathleen Peterson after she had sustained her wounds.
That's what he said.
And also that Todd Peterson went over there to get Mr. Peterson away from Kathleen at the time when emergency personnel were present.
Yes, aware of that as well.
And certainly then that would have the potential of Todd Peterson and any DNA. He may have picked up some DNA on his clothing or deposited some, depending on his movements, depending on his actions at that location. Is that correct?
Right, and that's why we opted to examine his clothing.
And the same could be said for Mr. Michael Peterson, correct? Is that correct? And having examined all of the, and also, you talked about previously, let me ask, because you testified at trial and then at another hearing as well as today, that at the time Kathleen Peterson was being moved, that her clothes were actually dripping blood, that she was wet. Do you recall that?
I don't recall testifying to that.
Okay, do you recall hearing about that?
No.
If if there had been testimony at the time her body was moved, that it was dripping blood, that would be indication that the blood was still wet and had not dried, correct?
In theory, there was scalp wounds, and so my assumption is, as you're picking the body up, could we expect some drainage from that? Yeah, possibly. The clothing were basically sweat material and therefore highly absorbent, right? So I'm expecting the blood to go in there and hold, not to drip through there. And looking at the photographs before they move the body, it doesn't appear to me that it's this environment that's still drenched in blood. But having picked the body up, again, with the amount of head wounds she had, could some blood have dripped down? It's possible, yeah.
I understand it's been a substantial period of time since you testified at trial and you dealt with numerous cases, but at that trial, there was a court reporter, correct?
I'm sorry?
At the trial, when you were testifying, there was a court reporter,
Yes,
and they were recording what you were stating.
correct.
Recall stating, and this would appear at page 11490, starting at line 20. That's a very substantial problem. Let me back up and ask a question, starting at line 11. Let me ask you specifically, I think testimony has been presented to the jury that Michael Peterson had access to the body, but I mean by that, he actually had cradled her or grabbed her, had to be physically pulled away from Kathleen. There has been testimony that her clothes were at that point still soaked with wet blood. What kind of effect on a scene can come from allowing someone like a family member to have access to the body in that situation? Recall answering to that question. That's a very substantial problem, and not only was it perhaps that her clothes were still wet, but you had wounds that were going to very likely continue to bleed or drain. You also have wet towels in the area, so there's a good probability there still was wet materials. Now that's wet materials. What about all the other dry evidence, trace evidence, fibers? Hairs, fibers, small particles that may help us associate where there was contact between Kathy and other items or areas of the stairwell. Obviously, a concern would be Michael Peterson's clothes and analysis of the clothes. Well, the mere fact that contact and the level of contact occurred between him and her and her clothing, it gets to the point that whatever we find later on, it is very subject to limited interpretation. Do you recall stating that, sir, as it appears in the transcripts at page 11490 through 11491?
Yes.
So having had the opportunity to have that the testimony refreshed, if her clothing is soaked and it's wet, then you would expect that if there's touch DNA on there, that there's a significant likelihood that it would be masked.
In the areas where there's blood staining, yes. In the areas where there's not blood staining, no.
Okay. What areas, now you examined her clothing, not only in the photographs, but also with the naked eye, and I think, as you testified here today, under different light sources and with magnification. Did you observe areas where there was tearing or something that, as you indicated, that would indicate to you that the item had been pulled?
On Kathleen's clothing?
Yes.
No.
And on Kathleen's clothing, So there's no tears or no rips that you see, is that correct?
Not that we identified, no.
And did you observe anything on there where sometimes when somebody grabs clothing, you can stretch it out and there can be a pull without actually having a tear? Did you observe and note that?
No.
And at the time that you testified, you indicated that, you recall indicating that there was, that you could not say that there was actual contamination at the time that you, at that point in time, at the time you were testifying, as it relates to Kathleen clothing or Michael Peterson's shorts.
Could you rephrase your question? I'm not clear
Okay.
what you're asking me.
Let me ask, as far as Michael Peterson's shorts,
Mhm.
do you recall testifying that there was no specific evidence of any contamination or alteration of the shorts? Do you recall your answer when asked that question?
I believe that's true.
That you did not, that you did not find any specific evidence that would support contamination? Is that right? I just want to be clear. And perhaps I'm not, that's me.
So, yes, it's contamination to the extent of a secondary, tertiary unknown individual, that's correct, yes.
That you did not see that?
Did not see that at that time.
Okay,
Right, and didn't test for it at the time.
okay. And the same question was posed to you regarding Kathleen Peterson and her sweatpants. And you didn't see any specific indication of contamination, is that correct?
Again, didn't see it and didn't test for it.
And if you had observed something that in your mind, based on your training and experience, could be an area of contamination or third-party DNA, whatever that may have been that you observed, would you have noted that and brought that to and brought attention to that detail?
Well, you're now getting outside the scope of what we were retained to do and what we did. What we were retained to do was to conduct a reconstruction and evaluate the evidence against two theories. Theory one, effectively, Kathleen fell, sustained injuries, and for a period of time moved about the stairwell until which time she finally expired. And at some point, indeed, that Michael did have contact with her and that toward the end in a resuscitation event. Theory two, she was beaten to death within the confines of the stairwell with a long cylindrical blowpoke object. So our evaluation was to look at all the evidence and determine what evidence was consistent with either or those proposed theories. And that was the scope of our work.
And within that scope, did you form an opinion?
We did.
Did you determine that, based on your expertise and the evidence that was examined by you, did you form an opinion that the evidence was inconsistent with an assault?
It was inconsistent with the theory of the assault presented by the defense. So the theory
You mean
that...
the state?
I'm sorry, with the state, yeah. So their theory that she was beaten in that confined area in a pre-described location with a blowpoke, indeed, the evidence was inconsistent with that theory.
And you, as far as the theory that there was an accident, there was a fall, did you form an opinion regarding that?
Yes, the evidence that we examined was consistent with the observations and the theory that she fell and hit her head in several locations in the stairwell, and then over a period of time, in an attempt to move about and before she expired, it created a majority of the evidence that we saw.
And the patterns, you said the majority of evidence, are you referring to the different blood patterns that, based on your opinion, were caused, and perhaps that of Dr. Lee, were from possibly aspiration or coughing or moving the head about, or even third parties who were trying to render aid as opposed to an assault, is that correct?
Correct.
And based on all the evidence that you observed, everything pointed to the fact that the injuries that were sustained there within that stairwell because of the blood that was present and absent from different locations within the household.
Correct.
Now, there were some, getting back to what happened within the courtroom, would you recognize some of, or portions of the trial that you observed on TV regarding the handling of evidence, sir?
Would I recognize them if you showed them
Yes.
to me?
Yes, sir.
Probably.
And even if you hadn't seen it, you are an expert in within a variety of forensic fields and have given opinions regarding the appropriate and proper way to handle evidence in a courtroom. Is that correct?
Correct.
And so even if you didn't see it before, you could, upon viewing it, being an expert, you could give an opinion as to what, if any, consequences there may have been as a result of the handling that you were observing.
Yes, I believe I could.
Your Honor, at this time, I would like to show the witness a video in order for him to see whether or not he recalls it, and if not, then go through and examine what is being depicted on that video. Now, I can tell the court I've let counsel know this in advance, and I'm going to mark this as State Exhibit 2. I don't use this. And Your Honor, just for the information, I don't put a sticker on the disc. I found that at times can prevent the very plane of the disc. I've written it right on the disc itself. And I do so with the court's permission, Your Honor.
Yes.
He had two 40-hour sessions of school to learn how to do this job, and this defense attorney is just ripping him apart. How do you prepare a witness for a defense attorney who acts like...
And we'll go to approximately 57 minutes.
maps of...
On State's Exhibit 1A.
Now, first, looking up on the screen, do you observe an individual standing there with looks like a bag in his hand?
Yes,
Do you recognize that person?
it's Attorney David Rudolph.
And you knew Mr. Rudolph to be the attorney for Mr. Peterson, is that correct?
Correct.
Do you recall viewing Mr. Rudolph's cross-examination of this witness, Dan George?
Parts of it?
Okay. Now, at this time, when we see Mr. Rudolph, does he appear to be wearing any gloves?
No.
If we look in the area where he is standing, that would be commonly referred to as a witness stand, is that correct?
Yes.
And there's a bar area, kind of flat area in front of that witness stand, in front of Mr. George, I believe there's a book, most likely a Bible, laying there,
Yes,
and there's also a bag as well, correct?
yes,
And there is not any type of paper put down on top of that. Is that correct?
yes,
And you don't know who touched that area previously, that being on the witness stand, do you?
no,
You don't know if someone went by and coughed on it before court began or during the break, do you?
no,
You don't know if somebody sneezed on it, do you?
no.
And ask if you recognize these.
Yes, sir, I do.
What are they? Could you take those out of the bag? Thank
Now,
you.
in response to, did you hear Ms. Ruoff ask the witness to take those items out of the bag?
No, sorry, I couldn't hear that.
Okay, I'm sorry. Let me just back it up just a little bit.
Yes, sir, I do.
What are they? Could you take those out of the bag? Thank you.
Do you hear it this time?
Yes,
And do you recognize that voice as being that of Mr. Rudolph?
yes,
And at this point, can you please confirm?
David Rudolph is a master at painting a picture for the jury. He's done it this whole trial. And by bringing up the specific pieces of evidence.
And I'm sorry, because I'm just going to ask you to repeat that, and I don't know if the court reporter heard it. I know sometimes in the past when there's a video, it's difficult to hear a witness stating, but did you observe Mr. George putting on gloves?
yes, you put on vinyl gloves.
He's doing it again.
Now, these are the shorts that Mr. Peterson was wearing.
And I just asked you to pay attention to Mr. Rudolph. Please pay, do you see any gloves on his hand?
No, sir.
Is this, based on your opinion, is that an appropriate manner to handle evidence that may contain biological evidence?
Not ideal.
In fact, it could result in contamination regarding touch DNA from Mr. Rudolph, correct?
It could.
Correct?
Yes, sir.
And you didn't take it from his person, correct?
That's correct.
They had been left on a window ledge, right?
That's correct.
And of course, the window ledge wasn't that wide, was it?
I didn't measure it.
At this time, you can determine the exact location where Mr. Rudolph is handling these items. And actually, the item that he's handling, do you recognize those as being the shorts that belonged and were retrieved from Mr. Michael Peterson?
Yes, I do.
And within this video, when we stop it, we can see exactly where Mr. Rudolph is handling that item without any gloves on.
Correct.
Tell you how wide it was.
In any event, the pants had been taken off of him at somewhere around 3:30, isn't that right? In the morning?
I'm not really sure what time they were taken off of him.
Well, you were there after 3:07 a.m., right?
I was.
And these weren't collected till 9:30 or 10 o'clock in the morning?
They were not collected by myself until that time.
That's what I'm asking.
That's correct.
And where they were left in the meantime was on a windowsill.
Did you see that Mr. Rudolph ran his hand all the way down the seam of the side of the pants?
Well, he relocated it. I couldn't say he ran it down the whole side, but yes, he did.
Okay.
Touch another portion of it.
And I'm sorry, I guess they're shorts, not pants.
Somewhere, right?
Yes, sir.
And that's not a proper place.
Back on the witness stand?
Okay. And there's no paper down there at all, is he?
No, sir.
Is there?
To keep shorts that may be wet with blood, is it?
I'm not here to determine what's the proper place to put them, no, sir.
I'm not asking you to determine it, I'm asking you to give me your opinion as a crime scene tech about whether or not you think it's appropriate to take a pair of bloody shorts and put them on a window ledge.
The manner in which Mr. Rudolph is handling this evidence, running his hands down the side of the evidence, putting it on a witness stand without any paper, putting his hands, palms right down on the evidence, is that an appropriate manner of handling evidence in court?
Again, not ideal.
And then could subject that evidence to contamination?
Possible.
And once contamination occurs, you can't unring the bell, you don't know, you can't separate out what happened before and what didn't, if there's DNA on there that doesn't, that, on that ledge that doesn't belong to Mr. Rudolph, may belong to an unknown third party, correct?
Well, so you got two questions there. So the transfer from Attorney Rudolph's, we could exclude out through testing because we get a known sample from him. And again, you're now talking about that secondary or tertiary transfer, if that's what you're referencing, from potential DNA to go from the witness stand back up to the cloth. And as I said several times, I'll say it again, that transfer rate is exceedingly small.
Okay.
So that's one that, in most cases, we don't anticipate to occur.
But it's possible.
Anything's possible, I suppose, yes.
For 6 hours.
I don't think it would have been appropriate, no, sir, but it's not, I mean, I've collected clothing on many scenes that have been there on numerous hours.
But it wouldn't have been appropriate. Here, we're talking about this case, right? Mr. Peterson is on trial for first-degree murder.
Yes, sir.
Sustained. Just ask your questions.
Yes, sir. It was not proper to take these shorts and lay them on a windowsill for 6 hours, correct?
That's correct. But and again, sir, I don't know who placed them there.
I understand. That's not what you would have done with them if they had been given to you, correct?
I would have placed them in a bag.
Now, if we fast forward,
And
I only direct your attention.
this time, sir, you still see Mr. Peterson's shorts on the witness ledge or bench?
Yes, I do.
And Mr. Rudolph at this time has now placed papers on top of those shorts, is that correct?
Correct.
And in fact, defense counsel, when talking about paperwork within the boxes at the clerk's office, you indicated at that time that, yes, there could be a transfer of DNA as a result of that paperwork within the box, isn't that correct?
It is correct.
And therefore, if there could be transfer from the paperwork as relates to another case, there certainly could be transfer as relates to the paper that Mr. Rudolph has placed on top of these shorts, isn't that correct?
Correct.
And you have no idea where that paper was beforehand, do you?
Do not,
You don't know who handled it beforehand, do you?
other than Attorney Rudolph, no.
And so you don't know, one, you don't know if there actually was contamination as a result of the paper being on the shorts, is that right?
Correct.
And if there is contamination, you can't say with certainty, absent testing, what that DNA profile is.
If it was there, and then again, if it did transfer, which, but yes, then I would not be able to know that.
To section 2.5.0. I've got it here, if it'll help.
okay.
And it talks about how to package the items, does it not?
an individual touching items and a potential for touch DNA being a contamination as a result of touch DNA. And you talked about, or asked questions about items of evidence being placed on a surface which may or may not have foreign DNA on it because we don't know what's on that surface. If different items of evidence are commingled, that could have potential of contaminating items. Is that right?
If they're exposed and they're in direct contact with each other, yes.
Okay.
Refused to take them, didn't they?
We see Mr. Rudolph, he's holding another item. You see it, and that's clearly not Mr. Peterson's shorts. Is that correct?
It's some different object, yes.
Let's back up then.
Brought the shirts, these shorts, remember, when you brought these shorts, and this is the shirt here, right? The blue shirt?
Yes, sir, it is.
When you brought these to the SBI lab, they initially refused to take them, didn't they?
I don't really remember whether they refused to take them or not.
So at that point in time, did you see where Mr. Rudolph placed that shirt?
It's somewhere there on that ledge where the bag and the shorts are.
Okay. And in contact with the shorts?
Appears to be part of it is, yes.
Didn't they tell you they wouldn't take them because there was too much transfer staining because of the way you packaged them?
Not because of the way I packaged them, no, sir.
What was your understanding about why they wouldn't take the clothing?
I don't recall at this time.
Okay.
Focusing in on these items of clothing. We see them still on the ledge there in the video, correct?
Yes.
And all this is happening in open court, correct?
Yes.
And this together in a single paper bag while they're moist.
Did you get an opportunity to see that, sir?
I just don't know what the other object is. I see the shorts, I'm not sure what that dark colored object is.
Okay.
What you can get is transfer blood, right?
That's correct. But as my testimony was earlier, the items that, when I transported them from Cedar Street to the police headquarters, they were moist but not.
So now we have the actions of David Rudolph. We have those shorts. We have a separate article of clothing being placed together inside of a bag. Is that right?
Yes, apparently.
And now, not only is there potential of commingling, actually there is commingling potential for contamination between that blue article of clothing that Mr. Rudolph handled and the shorts, but also to the interior of the bag as well. Isn't that correct?
Theoretically.
I mean, this is, okay. And as far as those items, as far as their commingling right now, that's even more so than what you saw in the photographs, as far as the condition of the evidence that's presented by the defense at this hearing, because now we have items mixed together and put in a single packaging. Isn't that correct, sir?
I wouldn't say it's more than that, because what you or I or nobody knows is the fact that you have a box that's, and back to the case here, where the evidence is fully open. So you move it, you walk with it, you jiggle it, joggle it. You have to assume that there could be a very substantial amount of contact. So I wouldn't say in this situation that we know it to be more, but yes, there was contact.
Okay. It gives the potential for contamination and damaging of evidence, correct?
Yes.
And just as there is the potential for contamination and commingling based on your opinion of the items that were contained within those photographs, the defense counsel showed you, right?
Yes.
But because you haven't actually done any testing, you can't say for certain that there actually has been a contamination, just the potential.
The potential is substantial enough that it precludes the ability to do testing and get meaningful results.
Well, okay, as far as meaningful results, if you only got one profile on there, that would tell you something, correct?
Well, if you're really at the touch threshold, then you also have to be concerned with that excessive handling could also practically knock off the small trace amounts of DNA as well. So once you get past the threshold and you start mishandling evidence and overhandling evidence, then that is also something to be considered.
And in order for you and Dr. Lee to perform your analysis, you had to remove it from a bag, correct?
Correct.
You had to then, with gloves on, you then had to basically, for lack of a better word, spread it out so you can see the entirety of the garment, correct?
And it's underneath butcher paper, which actually we re-secured, so they've kept that. So, and we handle it carefully, slowly. You know, so we know how to handle it to minimize the possibility of damage.
Did you observe any, during your examination of Kathleen Peterson's clothing, did you observe any type of items that you noted as potential DNA is falling off of Kathleen Peterson's clothing?
You can't make that observation. That's not a visual observation.
Moist enough to be any transfer be coming off with my gloves.
Now, you said you didn't seize the flip-flops.
Okay. You prepared, I don't know if it's a report or statement that I think was sent by email regarding your observations regarding at least one of the photographs. I don't know how many photographs you saw regarding the Peterson case. Is that correct? So that you sent to Mr. Klinkerson back, or at least it was dated, I don't know what date it was sent, but it was dated May 11, 2016.
Yes, I did.
And based on what you saw, the condition of the evidence, it could potentially have been damaged or contaminated, is that correct?
Correct.
But you can't say that with certainty.
The condition is such that you'd have to anticipate it, and it is such that it would not be ethically and scientifically responsible to do the analysis and have any reliability on the results.
But you could do a testing, correct?
You physically could do it, but again, scientifically, it'd be improper to render an opinion. So why do it?
And you could have done the testing before it ever was introduced into evidence, if the permission had been sought from the court.
Well, better yet, the first individuals that looked at it, the SBBI lab, could have done that.
Okay. And as well, it could also have been done at an independent lab, according to your testimony, correct?
In theory, yes.
And getting to theories, you did have a theory as relates to what occurred within that stairwell as a result of your blood pattern analysis. Is that correct?
It wasn't a singular theory, but the theory embraced the two scenarios. One would be, was the evidence consistent with Kathleen being beaten to death in the stairwell with the blow poke? And our opinion on that was no. And the other theory was the evidence consistent with her sustaining injuries, falling within the stairwell, and moving about for a period of time until she expired? And the answer to that was yes.
It wasn't just, were you aware that Dr. Lee, at page 11648 of the transcript, he didn't talk about just a blow poke, but it says, asked whether or not the evidence was consistent with a beating death, and he said it was not consistent with a beating death. Are you aware of that?
In essence, yes.
And you talked about a blow poke, but was there anything that you saw within, based on your expert opinion, that would be consistent with a beating death within the stairwell as opposed to an accident, a fall?
So the issue was whether an object, which would be a resultant of or attributed to a beating death, was present, and giving the injuries that were observed. What we did not observe was a cast-off that could be attributed to a weapon, and therefore the opinion that it was not consistent with a beating death within the stairwell.
Okay. And DNA evidence, and it was consistent, however, and correct me if I'm wrong, but was your opinion that the evidence was consistent with a fall, and that the additional cast-off that we're seeing was a result not of a beating, but as cough or aspiration or moving around?
Well, so part of the problem is you kind of flippantly used the term cast-off, and I think if you go back and review the trial transcript, we had a lot of opinions about particularly Agent Deaver's careless use of the word cast-off and inappropriate use of cast-off. So there were some stains within there that vernacularly could be associated with a cast-off, but it would have been blood being projected from hands or objects, towels perhaps, not from a weapon.
So, based on your expert opinion, did you see any evidence that would be consistent with a weapon being used?
No, sir.
And based on your expert opinion, was the blood pattern evidence consistent with a fall, an accident?
Yes.
And DNA evidence would not tell you or assist you in determining how the fall occurred, is that right?
It could. Well, the dynamics of the fall is really the orientations of where the injuries were relevant to a surface area that could attribute them, and DNA evidence wasn't necessary to do that.
Okay, so the DNA would not have, based on what you saw, and then led you to the conclusion that the evidence was consistent with the fall, DNA evidence would not affect that conclusion, is that right?
Well, we did not feel that we needed additional DNA evidence to evaluate those two theories, the one that she fell or secondarily that she was beat to death with a blow poke. We felt that for those two scenarios, we could address it without additional DNA testing.
And one scenario is, if it's a beating death, it's a crime. And another scenario, if it's an accident, a fall, unless there's evidence of a push, it's not a crime, correct?
Correct.
And DNA evidence, based on what you just said, would not in any way assist you in determining whether or not there was a push if there was a fall. Isn't that correct?
So what was, there was not an additional theory that a third party was engaged in a physical confrontation with her in the stairwell, and therefore we didn't evaluate for that.
There was, you examined not just the stairway, but also other areas of the house, is that correct?
Yes,
In fact, you were, in your testimony, you were asked questions about securing the entirety of the crime scene, which would have been, or the scene of potential crime, because if it's a fall and it's an accident, it's not a crime, would be the house itself, which I believe was approximately 10,000 square feet.
correct.
Did you see any or observe anything based on your review of any of the evidence that would be consistent with forced entry into the home?
So, no, but this is an important distinction. The crime scene per se, as the whole house, was released, with the exception of the stairwell, which was secured. So when we arrived at the house, the stairwell had boarding up on the both ends of it. It had been a protected, secured area. It was still more or less a secured crime scene. The rest of the house, that wasn't true.
Okay. Are you aware of any windows being broken?
I am not.
Are you aware of any doors door jambs being damaged such that would be consistent with a break-in?
I am not.
Are you aware of any witnesses indicating that they saw a third party exit or enter the house on that night? Other than ones that have already been attributed for that being emergency personnel, law enforcement, Todd Peterson, other than ones that you already knew about? Are you aware of an unknown third party that may have been seen entering or leaving the household?
I am not.
Thank you, sir. I have no further questions.
You're welcome.
I do, Your Honor.
All right.
Thank you. You were asked by the prosecutor whether or not you noticed any tearing or rips or pulls on Kathleen Peterson's clothing when you examined them with Dr. Lee, correct?
Yes,
And you said you did not notice that.
correct.
Did you notice any such type of cuttings, tears, rips on Michael Peterson's clothing?
I did not.
So that simple form of evidence that might show a struggle occurred was not on the clothing of either person?
Via tears, correct. Via visible indications to the clothing, correct.
Thank you. Okay, now, was there an opportunity, I mean, obviously, we all know Michael Peterson's clothing was tested for DNA, correct?
It's my understanding.
Was there an opportunity for the state to test Kathleen Peterson's clothing for DNA?
And, Your Honor, if I could I go back to the previous question? Because that wasn't a complete answer.
Okay.
What I understand about Michael's clothing is that his shirt was tested. I am not aware that anything else was tested. I don't know if it was, but I'm not aware of that. So then in response to your question about Kathleen's, I am not aware of any of her clothing having been tested for DNA.
So if, I'll come back to that. Now, you and Dr. Lee did not request DNA testing, correct?
Correct.
Was that your place in the course of the representation of Mr. Peterson?
I don't believe so.
And is there anything that the defense could have done that would have barred the state from doing its DNA testing?
Not that I'm aware of.
Because who had sole custody and control of that evidence? Her clothing and Michael Peterson's clothing.
That would be with the SBI, sorry.
And in a criminal case, who has the burden of proof?
Believe it to be the state or the county.
And that burden of proof is proof beyond a reasonable doubt, correct?
It's my understanding.
At this point in time, in this case, the state's blood spatter expert, as you know, has been discredited, correct?
Correct?
And therefore, the case with a new trial is starting all over again.
I assume it would have to, yes.
If the DNA analysis had been done in December or January, I mean immediately after Kathleen Peterson died, would that have been best practice?
Yes.
Would that have been optimal?
Yes.
Would there have been the questions about whether there was contamination in the courtroom during the trial?
You still could have raised a point, but it wouldn't have had the same outcome
And that is why.
because we would have had the test results that we could rely on.
And we don't have them, correct?
We don't.
And ultimately, even how the evidence was stored after trial would not have been an issue if the state had done the DNA analysis of Kathleen Peterson's clothing at the time she died.
Correct.
Because the results would have been in existence.
Correct.
Very well. And when you examined, you stated that you examined Michael Peterson's clothing. I believe you also examined his clothing for evidence of cast-off of Kathleen Peterson's blood?
Certainly.
And you would have looked at that if because the theory was a long cylindrical object was the weapon. And if there's cast-off, you would have expected spray, perhaps on his shirt,
Perhaps, yes.
on the back,
Yes.
linear pattern.
Yes, it'd be
Did you
consistent
find-
with the dimensions of the object containing the blood.
Was there any?
There was not.
Now, on the video you were shown with Mr. Rudolph and investigator George, they were only handling Michael Peterson's clothing. Those were Michael Peterson shorts, correct?
I truly don't know what that dark-colored object was, but that was Michael Peterson's shorts. Yes.
Okay. But his clothing had been tested for DNA, had it not?
Again, I'm only aware of the fact that his shirt was tested.
It was your conclusion and Dr. Lee's conclusion that the evidence in the staircase, in the stairwell, where Kathleen Peterson's body was located, did not support an argument that she was killed by an attack by someone with a long cylindrical object, correct?
Correct.
And you did conclude, it was your expert opinion, that she died as the result of a fall, correct?
Well, the evidence is consistent. Our evidence and evaluation is consistent with that. Yes.
Very well. If this case were retried, that would be the testimony if you were recalled as a witness, correct?
Yeah, assuming that there's no new evidence that I'm later made aware of, yes.
And is it possible to get new DNA evidence in this case at this point in time with the evidence and the condition it's in?
No.
No further questions.
You're not aware of any additional evidence that's become available since the time that you drafted and signed State Exhibit Number 1 that's been identified as a report that you prepared?
I'm not. I'm not.
And in fact, according to your previous testimony, if
Well,
you...
well, actually, sir, can I step back?
Yeah,
The actual blow poke was recovered at a point subsequent to this report.
okay. You're assuming that that was a blow poke?
There was a blow poke recovered from the Peterson residence subsequent to the issuance of this report.
Do you still stand by your report?
Yes, I do.
And as you testified earlier, DNA evidence would not affect your opinion regarding whether or not there was a fall, or the evidence was consistent with the fall.
Correct.
Thank you. I have no further question of this witness, Your Honor.
Anything else?
No, sir, Your Honor.
All right, you can come down.
Thank you, Your Honor.
Can you please, this, I'll grab it.
You want the report too?
Have a moment, Your Honor.
Yes, okay. Well, no, okay, that's fine.
In Mike's, in our motion.
Yeah, everything here? I'll wait to find it. Are you thinking of anything else?
Put so much in, 35.
Can I ask you a question? Have you tried to call this again?
Will you stand up? This is the truth. May we have a moment, Your Honor?
Let me just turn this so they can hear everything. Are you asking me for this to come in? Let me just step. No, we would like to talk such that we're not being overheard by the mics.
Well, why don't we do this? Why don't we take our lunch break now? Let's come back at 2:30. I need to see the district attorney, unrelated to this case. Can you have him come to my office?
Mr. Eccles?
Yes.
We'll do that now.
All right, 2:30.
What's the recess till 2:30?
We still may get to it. You know what you're asking?